Today we are going to discuss four questions. Let me start with the first question, which is tort is a civil wrong and not all civil wrongs are tort. So this is one of the commonly asked questions. Before we begin, I would follow a pattern of where I talk about the introduction or the statement from a legal term. I will explain what is that legal term and how do we look at it, and then I would take the case laws because case laws are very important when you are answering the questions. And I would also take an Indian position and see if we have a slightly different from an British position, English position, or a global position, how it would be referring to. So you can follow this pattern wherein you go with a statement, explanation, case law, and Indian position, or depending on what type of evaluation is done in your university, you can fine tune this pattern so that you can answer the question and also demonstrate not just a memory but also a legal mindset. So back to the question, which is tort is a civil wrong and not all civil wrongs are tort. To understand this, we have to first look at the part like there are two things. If we take a broader context and a specific context, the broader context we say as genus, and the specific context we say it as species. So the broader context is Winfield theory, wherein we know any sort of injuries which are causing harm are prima facie torts where a lawful justification exists. This theory is very flexible, which allows tort law to expand. Maybe it covers new types of things, like maybe you can talk about a privacy issue, a cyber harm being done. As and when the society changes, this theory will also keep changing. But any sort of injuries which are causing harm are prima facie tort. This is what and Winfield theory says. But you have to note that this is only meant for the lawful justification. It doesn't apply to the religious, religious torts and other moral torts and all will not be applicable. It is only for the lawful justification. In principle, this says that any unjustified wrong leading to harm is actionable. Whereas Salmon theory is quite opposite, wherein it is very specific. That's why it's even popularly called as pigeonhole theory. That means you have a specific set of holes wherein a specific set of pigeons can pass through. That means they are very well defined and not a very generic principle. Therefore, the number of holes are fixed, the pigeons which can pass through it are also fixed. So here you can see like battery, negligence, nuisance being caused, those kind of acts are called as tort. Therefore, according to Salmon's theory, an act is only a tort only if it is slot in one of these categories. And if any injury does not fit into a known category, no liability rises, making it very rigid. So this is prima facie the definition of tort, that is Latin term tortum, which is means twisted behavior. It refers to a conduct which is twisted or crooked. It is fundamentally a civil wrong. And civil wrongs is a broader category that can also include breach of contract, breach of trust, other equations out here. But tort is a very specific of the broad category of civil wrongs. Therefore, all civil wrongs cannot be tort, and tort is a very specific set of civil wrongs. Now, in order for tort to be distinguished from the other civil wrongs, we look at three criteria. What is the nature of the tort? Whether that tort is something which is not codified, but it is a duty which is imposed by law. That means we spoke about the cricket match example, wherein somebody spilling hot tea on you is something which is not justified. One person's duty is to be careful and not cause harm to others intentionally or unintentionally. Therefore, in that case, a tort has been done towards another person. Whereas contract is very specific and duty is created by the consent of both the parties, and it is very specific out there. Second part is what is the nature of damage being done. In the tort, we have to always remember that the damages is decided by the court. Therefore, we always call it as unliquidated damages. In contracts, the damages are often liquidated, which are predetermined, and we come to an agreement in case of each one of them are not abiding by the contract, what is the damages which they have to pay. And lastly, tort is not a crime. Crime is against the state, tort is against an individual. So, in crime is an act against the state. So, we have to make sure that this does not get repeated, and states takes cognizance here. Tort is something which is done against a certain individual, and it is not justifiable, and usually the compensation is form of money, whereas in crime it is in form of money, jail. Those are the major difference between tort and crime. Lastly, you can talk about the important case laws. So you can talk about Donig versus Stevenson, wherein we know that a manufacturer has a duty of care to the ultimate consumer, even there is a contract or no contract. This was one of the cases where the liability of the manufacturer was fixed, and there is no private agreement, but still a manufacturer has a duty which he has to do according to the law, and that's one of the case laws. If we look at Indian legal system, we follow Winfledian school, wherein we are not having any codified set of laws, but we are mostly fluid concept. We have laws of tort, which is any sort of injuries which is being done to another are called as torts unless justified by law, and this is clearly separable from the Indian contract law what we have, or the BNS what we have, because BNS is more codified, Indian contract law is more specific between two parties or more than two parties, whereas tort law we don't have anything in specific. So these are the things which you can take care and answer your queries. Now we move on to the second question, which is injuria sine damno versus damnum sine injuria. The first part here is establishing what type of category it is. If it is a legal injury without financial or physical loss but actionable, we call it as injuria sine damno. Second part is it is a physical or a financial loss without legal injury, not actionable, then we call it as damnum sine injuria. Now, for the first part, the infringement of the legal rights itself is a wrong. And even though the plaintiff is actually benefited by the act, but still we say that it does not protect against all losses, only the infringement is wrong. In the second part, we say that even though the defendant's act may be harmful, but it is legally justifiable. Because it is, as we take a common example of Gloucester Grammar School, we say that lawful competition is, it's going to hurt someone, but it is legally justifiable. It is not something that you can't open another school in the same area, because that is what the popular case was about, that a new school came up in the same area and it causes financial losses. But the court said no action can be done because competition is not a legal injury. It is not something that which the court can restrict. Whereas if we talk about Ashby versus White, where White as an officer was controlling Ashby or preventing Ashby from voting, even though there was no loss suffered because the contestant which Ashby wanted to support won anyway, but the court awarded damages because his legal right was violated. Now, if we take from an Indian context, we also follow the similar principles. One of the popular case in India was Bhim Singh versus state of Jammu Kashmir in 1985. The Supreme Court quoted this case of Ashby versus White at that judgment, and it is said that the illegal detention of an MLA was a violation of his legal right, and therefore compensation was to be provided despite there was no tangible losses. So here we talk about these two concepts, injuria sine damno versus damnum sine injuria. Always remember what is actionable and what is not actionable in considering the physical and financial losses. Now let's move on to the next one, which is Ubijus CB remedium, and which we usually say like whenever where there is a right, there is a remedy. So always remember, if you can't remember the Latin phrase, you can use the English one, which is called where there is a right, there is a remedy. This is the foundation of law of torts, wherein we say that in a legal system, it is a right which is very important. If we don't recognize the legal right, then the legal system itself is incomplete. And if we don't provide any mechanism for enforcement or readdressal, it is something which as a society we will fail. So we have to make sure that wherever there is a right, there is a remedy. That means no wrong should go unaddressed if it is being capable of remedied by a court of law. So, if a legal right has been recognized by the law, that right has been violated, and if an existing remedy is iniquitable, or if any specific remedies are not there, then the law will provide no other specific remedy, nor the existing remedy is inadequate. So, if we take again the popular Ashby versus White case law, the judge, Lord Holt, famously stated that if the plaintiff has a right, he must be of necessity have a means to vindicate and maintain it. It is a vain thing to imagine a right without a remedy. So, what is the use of having a right, and if it is being violated, and if no remedy is given to it? So, it should be either in form of some action, some compensation that has to be done because a right has been violated. Otherwise, the existing of right itself does not make any sense. If we take this into our Indian context, this has been seen in our constitution itself. Article 32, Article 226, lot of judgments in Supreme Court and High Court have given and remedies for the violation of fundamental rights. And we also have something like a constitutional tort, wherein we have seen Behra versus State of Orissa, where the state was held liable to pay compensation for the misconduct of the officers. So that shows that even the state has a duty or to be performed towards its citizens. Citizens have a right to demand services, and because that's something which they give it as a part of a fundamental right. And since there was a violation of this fundamental right, the court went ahead and ordered a compensation to be paid in the case of Neelabati Behera versus State of Orissa. So this is one of the case laws which you can go for. Lastly, we come to the question, how did the origin and development of law of torts have happened in India? So the law of torts in India is kind of a borrowed branch, we can say, primarily based on the English common law. And we always say that law of torts in India is uncodified because we don't have any specific set of laws, coded rules, or any single statute in parliament. Mostly, as I said, it is decided by the judges. So it is based on the judgment which is given by the judge and the principles which are derived based on the previous court decisions, which will help the judges to make decisions. And the best example of the law is, or the case laws here is that MC Mehta versus Union of India in 1987. It said that for a country like India, we have to make a rule of absolute liability for hazardous industries, and that's how the liability came into picture. And even though we have got tort laws through the Charter of 1726, wherein the tort laws officially entered India through this, a codified version, but there are no specific laws. We, as I always say, that justice, equity, and good conscience is applied by the judges, and courts are always using this three principles. We do have some areas where are very specific, like maybe Motor Vehicle Act or Consumer Protection Act. But the core principles of torts being committed, like negligence, nuisance, defamation, most of them are uncodified, and judgment are made by the judges. So with this, I would conclude all the four questions. I have left the notes on the video. Please go through that. And as I said, go follow the principle of statement, explanation, case laws, and Indian positions. Okay. Thank you. Have a nice exams and learning. Wish you all the best from my side.